Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts, and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA, or Latin America to learn how to manage your IP assets and expand your business successfully.
Good morning, Europe, and good afternoon, Southeast Asia. Welcome to our webinar entitled Avoiding IP Disputes Before the Courts Using Alternative Dispute Resolution in Southeast Asia. I'm happy to welcome you all on behalf of the Southeast Asia IP SME Helpdesk project. My name is Nora. I'm the project manager for the Southeast Asia IP SME Helpdesk project. I will be today's webinar's moderator together with my colleague Benoit Tardy, IP business advisor of the project. Before we get started, let me quickly go through the housekeeping rules. So most important, what you need to note down is you should ask questions throughout the webinar. So please feel free to use the chat box on the screen and type in any questions you may have, and we will address it during the Q&A session. Today's webinar is recorded, so you will be able to access the webinar later on through our website or download the presentations. And if you have any technical problem, just contact the organizers and we will assist you. So for this webinar today, we will have 4 outstanding speakers. So let me quickly introduce you to the speakers. The first speaker will be Jevon, external expert of the Southeast Asia IP SME Helpdesk project and partner at Shook Lin and Wook, Singaporean law firm. We have Chiara Accornero, representative of WIPO and the Arbitration and Mediation Center in Singapore. And we have Doan, also external expert of the IPR SME Helpdesk project in Vietnam and working for VICMC law firm managing partner. And then joining us as well, Tran, Accredited Mediator and Deputy Director of the Relation Affairs at Vietnam International Commercial Mediation Center. So let's have a quick look at the agenda. I will take a very few minutes from you to introduce you to the project in case you missed our video. After Jevon will give you an overview about alternative dispute resolution in Singapore. Chiara will present on WIPO's role. Doan will update you on commercial mediation and current practices in Vietnam, and Huong will be explaining you further on resolving IP disputes by commercial mediation in Vietnam. And then we will discuss with you any questions you have. So the Helpdesk is an initiative of the European Commission. Our goal is to support EU SMEs to protect and enforce their intellectual property rights in relation to Southeast Asia. All services we offer to European SMEs are free of charge. You can see on the slide, so we have an inquiry helpline. You can get in touch with us via email, phone, or if you happen to be in Vietnam, also physically, normally, without the COVID context. And we reply any IP questions you have within 3 working days. We organize trainings online and on-site in Southeast Asia and Europe throughout the year, like today's webinar. We have a wide variety of guides and fact sheets available on our website on various IP topics, and also country fact sheets related to the 10 ASEAN countries. And we also offer some interactive learning tools such as e-learning modules, videos, and infographics. So without any further ado, I would like to hand over it now to Jevon, our first speaker. So if Jevon, you can share your slide. Okay, perfect.
Thank you, Nora.
All good.
So thank you everyone for joining us. Good morning to those of you in Europe, and good afternoon to those in Asia. So today I'll be talking about ADR, or Alternative Dispute Resolution, from the Singapore perspective. So this is my bio, but I don't want to bore you with it. So if you're interested, you can just look up the firm, and my bio is online, or you can look me up on LinkedIn as well. For today's, the part that I'm going to be covering will be an introduction to ADR. ADR against litigation, what are the differences, and the different types of ADR mechanisms in Singapore that are available, as well as ADR has used in IP disputes, right, which is what we're really here about. And finally, drafting of ADR clauses in contracts and some of the considerations that go into that. So before we start off, just a bit of a pop quiz to get the juices flowing. Which of the following are alternative dispute resolution mechanisms? So you have 4 options there. A, arbitration between 2 adversarial parties. B, mediation and negotiation. C, neutral evaluation and expert determination. Or D, all of the above. I think Nora's going to be launching the poll now. So you have about 30 seconds or so to make a choice, and then we'll just have a look at the answers to see where everyone stands.
Yes, correct. We really want to see what you think, so please participate in the poll. There is no good or bad answer. We will not disclose the details, who said what, so. Okay, I think we can share the result. So,
right. So it's interesting. We have 3% who have selected just arbitration between 2 adversarial parties, 17% who went with mediation and negotiation, again 3% with neutral evaluation, and the majority, 76%, selecting all of the above. Well, in truth, all of them are actually different mechanisms that amount to ADR in Singapore. So if you had selected one of them, you would have been at least partially correct. Selected all of the above, then yeah, that's also right. So moving on, now we're going to get into the meat of the substance, meat of the matter, and that's really about what is ADR. ADR is a range of procedures to resolve disputes without going to court. That's one of the key features. You don't go to court. You don't have a trial in court. It may involve the assistance of a third party, such as an independent, a mediator, arbitrator, or an expert. Not all ADR mechanisms involve a third party, but most do. One of the key conditions of ADR is really consent of parties. Both parties or the parties to a dispute have to come together and agree that they want to use ADR to settle their disputes. So they can either agree before the dispute even comes about. So during contractual negotiations or they're drafting their contracts, they can already agree that any disputes that are coming up will be solved by some ADR mechanism. Or even after the dispute has come about, it's also possible for parties to then agree that they want to use ADR as a means to resolve the dispute between them. So litigation versus ADR, what are the key differences? And in some cases, I'll just point out that there may not be actual differences between the two. So first one, time consuming. Generally, litigation is more time consuming than ADR, but certain ADR mechanisms can also be very intensive, right? Such as arbitration, that can be quite intensive and perhaps even as long or even longer than some litigation processes. Higher costs, that's generally true. ADR, most of the mechanisms, again, are likely to have lower costs involved, but arbitration sometimes can also have significant costs. Multi-jurisdictional litigation, that can be quite complex, versus ADR can have a single procedure, but that's also dependent upon whether various agreements in place are all covered by the same ADR clauses, right? So sometimes you have different contracts in different jurisdictions, and that gives rise to multi-jurisdictional litigation. But if those contracts are all governed by different ADR clauses, which we'll talk about when we talk about drafting the ADR clauses, then it can still give rise to a plurality of disputes potentially. And again, while parties can agree to consolidate, it's dependent upon consent being reached again to consolidate the different proceedings under a single ADR proceeding. Adversarial in nature, that's litigation. ADR can also be adversarial when it comes to arbitration, for example, but most of the processes that are involved, such as negotiation, mediation, conciliation, and even expert determination, you tend to have a third party involved who's actually trying to work with parties to maintain or salvage the business relationship, if that's possible. So that goes to the next point, which is in ADR for mediation, for example, you try to get a win-win solution because it's a flexible mechanism. Whereas with litigation, it's quite fixed. You either win or lose. When it comes to autonomy, there's more flexibility under ADR. The tribunals, the mediators, the parties can also conduct their proceedings in a manner that they feel fits them best. Whereas for courts and litigation proceedings, they're very formal. There are legal procedural laws and regulations that have to be complied with. And a very key key difference is privacy. For ADR, you have confidentiality, whereas for court proceedings, they are open to the public. The next point about home court advantage does apply in litigation proceedings. For ADR, it really depends upon the clause that is the governing clause for the ADR mechanism. You can have jurisdiction neutrality, or sometimes, depending upon the drafting of the clause, it may actually confer a home ground advantage also, either home ground advantage or possibly even having a governing law that is to your advantage, right? So the final distinction between litigation and ADR that the court decision is open to appeal. There's usually an appellate process, 1 or 2 instances of that even. Whereas in ADR, there is finality. If you reach a settlement agreement under mediation, then that is it. Any disagreements or disputes that later arise are not in relation to the earlier dispute, but will be in relation to the settlement agreement that was reached. Likewise, for arbitration, there's an arbitral award that is issued, and that can only be set aside under very limited, narrow circumstances, and there's typically no appeal, right, from an arbitration award. We now go on to talk about some of the ADR mechanisms that are in Singapore. You can see them listed in the left-hand column: negotiation, conciliation, neutral evaluation, expert determination, mediation, and arbitration. Right? We're going to be focusing more on the latter 3, but I'm just covering the first 3 for a matter of completeness. Negotiation, there isn't an institution that's needed to administer that because it's between the parties. Conciliation and neutral evaluation is something that is unique to our state courts in Singapore. So in Singapore, we have the state court, and then you have the high court and the court of appeal. So those are the different levels of the court. And conciliation and neutral evaluation is something that's offered at the state courts in Singapore. And it focuses more on community disputes between neighbors, for example, or families. Expert determination is provided in Singapore by the WIPO Arbitration and Mediation Center, and Chiara will be covering that in more details. I won't say more. Mediation is also provided for by WIPO AMC, the state courts, the Singapore Mediation Center, the Singapore International Mediation Center. So the difference here is that the Singapore Mediation Center tends to focus more on mediation proceedings where both parties are Singapore parties, whereas the Singapore International Mediation Center focuses on disputes where one party is, both parties can also be foreign, right? So you can have a foreign or local party, and SIMC aims to cater for that kind of particular situation. And then we have the Law Society, which also has mediation services. Arbitration, again, WIPO AMC provides arbitration services. You have Singapore's SIAC, the Singapore International Arbitration Center, quite very well renowned. And I think the latest statistics was that the second most number of arbitrations in the world, just behind London. You also have the ICC that provides arbitration services in Singapore, and the Law Society as well. We're just going to delve a little bit into the specifics of ADR and the different mechanisms. So for negotiation, this is a private discussion between parties to try and reach a consensus or an agreement amongst themselves to resolve the dispute. It's entirely party-driven. So there's no additional cost because there's no third party appointed. But you do not have recourse to any institutional support. Sometimes not having a third party involved can lead to one party where there's an imbalance of power, one party having an advantage over the other. And in this case, where you have negotiation, of course, there's no guaranteed resolution because parties may not reach an agreement. Conciliation is the first ADR mechanism where you have a third party involved. So this is something that under the Singapore state courts, where you have a judge of the state courts who is with the parties, but the judge does not opine on the merits of the dispute. Instead, he simply tries to facilitate some sort of resolution between the parties. And that's why it's more apt for community-based matters or disputes. Neutral evaluation, and I've used the term judge, but in this case, it doesn't actually necessarily have to be an actual judge. It's more like an adjudicator. In this case, it differs from conciliation because here, the adjudicator is going to provide some opinion or some view on the likely outcome of the dispute. And that can be quite effective and useful for parties to then decide whether they want to continue on with the dispute or if they want to try to find some sort of resolution to it. Again, this is something that's provided by the state courts in Singapore. Expert determination is, I think, the first mechanism that comes into the realm of the IP dispute area. because this is something that you can imagine. It requires an expert in the technical or scientific field. So especially when you have IP disputes over technical subject matter, this is one mechanism that parties can choose to avail of. They can select a very specific individual who has specific background knowledge or qualifications to maybe decide on an entire matter or even on specific issues that could very well decide the matter as a whole, right? So parties can choose to be bound or not by the determination. So it's either binding or non-binding. And it's important to be, if you're going to use expert determination, it's very important that you choose an institution that has a sufficiently large panel of technical experts or scientific experts, as the case may be, right? You don't want to be to select an institution that does not have that level of expertise, the depth or the breadth of it. But that comes into play when you are drafting your ADR clause, which we'll talk about later. Mediation. Here you have a third party who the mediator actively is involved in the mediation process to help parties find a solution. So this is the mechanism where the win-win approach that I spoke about earlier on is most likely to occur. Here, as I mentioned, there are several institutions that provide mediation services. I actually just a month ago, I came off a WIPO administered mediation. And the approach of the mediators, they play a very critical role because they are able to, if parties are already willing to mediate and come together to solve an issue, then they play a very facilitative role. But sometimes when there's an impasse reached, mediators play a very important role of helping to nudge and push parties along, either by even opining sometimes on their personal views on the merits or some of the issues that are likely to be faced by parties if they pursue a dispute resolution in court. Then things like that can be very helpful, especially when it comes from a third party who doesn't have any vested interest, to get parties to relook the dispute, to rethink whether they actually want to resolve it or not. Finally, we have arbitration, which is, I think, probably something that most are aware of. It's a private system of adjudication. Parties refer their dispute to an arbitral tribunal of their choice, and you have to accept the tribunal's decision if it's final and binding. Right? Arbitration is, in some sense, very similar to litigation, and which is why some of the differences I mentioned earlier may not necessarily apply to arbitration. Right? Cost-wise, sometimes it could be as expensive as litigation. Sometimes it could take as long as litigation also. The main benefit of arbitration over litigation is really the privacy that you get for your matters, because parties are bound by confidentiality under the various arbitration institutional rules. Now we're on to the next poll question for the day. So very quickly, what types of IP disputes can ADR apply to? So you have A, infringement of patents, trademarks, and registered designs. B, breach of confidence, loss of trade secrets, and violations of copyright. C, only contractual disputes involving IP. Or D, all of the above.
Okay, so we will again leave 30 seconds for the participants to select their preferred answer, and then we will share the result and Jevon will comment on it. Okay. Let's share the result. Okay, so this D option is very popular today.
That's right. So that's correct. All of the above. I asked this question really because in some circles or some schools of thought, there's certain thinking that ADR may not be applicable to certain types of disputes or certain disputes of a certain nature, but that's incorrect. ADR can apply to any type of IP dispute. And the interesting thing is that apart from infringement, although it's not one of the options, in Singapore, the International Arbitration Act has been amended to clarify that even the validity of registered rights such as patents, trademarks, and registered designs can also be arbitrated, right? So that has been a source of tension sometimes in some jurisdictions, but in Singapore it's been clarified that if you want to have arbitration for the validity of patents or trademarks, that's fine as well. So now we're going to go on to ADR in IP disputes. So as alluded to in the poll, what kinds of disputes can ADR apply to? So you have your contractual disputes, which anticipate a possible future dispute. And examples of that are found in your employment contracts. For example, breach of confidence. You have your IP licensing or contractual franchising agreements or distributorship agreements, assignments of IP, that too. You can have your ADR clauses built into these contracts so that any disputes that arise from them will be subject to the ADR mechanism chosen. But as I said at the start, you can have ADR also applying to non-contractual disputes. So even when you have, let's say, an ongoing court matter for breach of confidence, or even before court matters start, if parties actually come together and decide that they would prefer to resolve it using ADR, so there's consensus, there's consent from the parties, they can then refer it to the appropriate institution and have their dispute either mediated, arbitrated, or so on, right? So you have breach of confidence, copyright, patent infringement claims also, even passing off. The point about ADR and IP disputes is, and that doesn't change no matter what, is that one, it has to be voluntary. So in Singapore, there's it is very much baked into the system. It's built in, as I mentioned earlier, for the state court level, it's very prevalent. But even for high court disputes, it is also part of the process. Because it's voluntary, parties have to respond to the court and inform the court whether or not they're agreeable at a very early stage of proceedings. So probably about 3 months in or 4 months into the proceedings, you have to tell the court in a declaration whether or not the party is open to ADR, and by that we mean mediation typically. So if parties consent to ADR, mediation, the court will stay proceedings and let parties work out the timelines and go for mediation. And I've even done a case where the court has granted extensions of time instead of moving forward, almost 4 months, because parties couldn't resolve the matter during mediation, which is just 1 day, and they needed a lot more time. But the court was willing to delay the matter for almost up to 4 months so that the agreement could be hammered out and the matter resolved without parties having to actually take any further steps in litigation. So Singapore courts are very supportive of ADR, especially mediation within the framework of a dispute that may have already started. So one of the things that happened was that the Intellectual Property Dispute Resolution Act in 2019 that was passed, and that's what I mentioned, where various amendments to statutes and so on had taken place, where most civil IP disputes are now consolidated in the High Court. And as a result of that, it is almost a given that they will all have to undergo some form of ADR, right? Provided there's consent by the parties. You can opt out for ADR if you can give a good reason. For example, if there's a public policy reason why this issue needs to be heard by the court in a decision rendered. So if there's a novel issue of law, for example, that's also acceptable as a good reason why you may not want to proceed with mediation. Otherwise, if parties simply refuse to proceed with mediation just because, after the dispute has ended when it comes to awarding costs. So in Singapore, we have a structure where the winning party can get costs. If the winning party refused mediation for no good reason, then the costs awarded can be significantly reduced. So there is a cost consideration also if a party wants to opt out from ADR under Singapore law. We now come to the final part of the presentation, which is drafting an ADR clause. A clause is something, this ADR clause can be inserted into contractual documents so that if there's a dispute that arises, there's already an agreed resolution mechanism in place. This fulfills the key condition of ADR, which is consent. Right? ADR clauses in contracts ensure that the contracting parties elect ADR as an alternative mechanism to litigation. It also allows parties to have certainty and control over the dispute resolution mechanism that's to be utilized. So it's always advisable to have a well thought out ADR clause in your contracts. One point that I think parties tend to gloss over is that ADR clauses tend to come in the boilerplate clauses in your contracts, right? And sometimes negotiations have gone on for so long with the commercial terms that you just gloss over the boilerplate clauses. But actually, that's a mistake. It's very important to have your ADR thought through, especially on the institution to choose, because some institutions have different strengths. Some are stronger in, let's say, maritime, some are better in IP, and others in commercial disputes because of the different panels of arbitrators or mediators they have, the governing law of your contract and how it plays out, where, as in the actual venue where the mediation or arbitration may take place, right? These are all factors that should be considered by a party when you're drafting your ADR clause. So with that, just to sum up, ADR has advantages over litigation in some instances. There's a variety of ADR options available in Singapore. You have to choose and combine your options that best addresses your needs, right? So it's not a standard thing to simply plug and put in. ADR requires consent, and that takes the form of an agreement. And it's very important to have the proper drafting of an ADR clause to take into consideration parties' choices. So with that, I will now hand over to Chiara. So it's going to take us through the WIPO mediation and arbitration portion of things. Chiara.
Thank you, Jevon, for your presentation. There was one question, so I thought we could already address it now. We don't need to wait until the end. So what the question was, what are the differences between conciliation and mediation? Very often those two words are used alternatively. Would you like to comment on that?
Sorry, could you repeat the question again, Nora?
Yeah, sorry. What are the differences between conciliation and mediation? Very often those two words are used alternatively.
Well, I think as a process, they're very close, they're very similar. But conciliation, at least in the Singapore context, involves an actual judge of the state court. So he could potentially be the actual judge who might be hearing the dispute if it proceeds further, or another judge who's assigned from the court itself. Whereas for mediation, your mediator is really, it can be a retired judge, usually not an active judge who's taking part in it. It's any party who's suitably qualified as a mediator. It doesn't have to be a legally qualified person. I've had a mediation with someone who was not a legally qualified person. So you don't, I think that's one of the key differences, at least, that I see between mediation and conciliation.
Yeah, okay, thank you very much for the clarification. And yes, let's move to Chiara's presentation now. So Chiara, are you here? Okay, so.
Thank you, Jevon. Hello, everyone. And thank you very much for attending this session. So my name is Chiara, and I spent the last 3 years in Singapore as the representative of the WIPO Arbitration and Mediation Center. So the idea for this short presentation today is to share the experience of the WIPO Arbitration and Mediation Center mediating and arbitrating intellectual property disputes in particular. And I would also like to put a particular focus on SMEs, because SMEs also represent almost 40% of the parties that we see in our cases. And we've also very recently developed some special schemes and reductions whenever SMEs are involved. Now, I'm sure most of you are probably already familiar with WIPO, the World Intellectual Property Organization. Probably many of you have already used some of the services offered by WIPO, for example, to register internationally a trademark, a design, a patent. Now, something else that WIPO does for businesses is also mediation and arbitration of IP disputes. And that's what we do at the center. And really the idea behind also the creation of the center itself was to find ways for businesses to resolve their disputes in the most efficient way as possible. So really to reduce the impact the disputes have, so that parties can just go back to their business. Now, I have a couple of screens I wanted to show you, and I wanted to start basically where Jevon left. So some of the advantages of mediation and arbitration, so some of the reasons why this could be some helpful options for you. And of course, I don't want to repeat what Jevon said, but I also wanted to give you some details on the WIPO rules and our experience to give it some context as well. So of course, time and cost are the main advantages of mediation and arbitration, in particular mediation. It can be as quick as a few weeks, really. We've seen that generally the average duration had always been 3 to 4 months, but now in the last years, where meetings can also take place online, we've seen really mediations taking place in as little as 3 weeks. So it can be a very quick option, and also the cost efficiency in mediation is very high. So mediation is much cheaper than arbitration or core litigation, and in a way, we've also seen that in practice, using, for example, online means to have mediation sessions is another way to contain costs, because parties don't have to travel, they don't have to rent meeting rooms. And of course, something that we do at the center is we also help parties negotiate the fees of the mediators depending on the case, especially in cases involving SMEs or startups. Costs can be quite a sensitive matter, so that's also something that we do. Of course, then intellectual property are very specific. And one of the advantages of mediation and arbitration is that parties can select, they can choose a mediator or an arbitrator with a specific expertise in intellectual property, be it software, be it trademarks, copyright, designs. And again, we can help. We have a database of experts that we can suggest in our cases. And also very often, and this is not just for multinational companies or big corporations, but also for SMEs, startups, even individuals, very, very often intellectual property related collaboration have an international dimensions. So there are collaborations with partners based in other countries, or for example, there are different laws or jurisdictions which are involved in a collaboration. And mediation or arbitration, they really allow you to resolve the disputes in all those potential jurisdictions only in one procedure. So at the end of the day, that also saves a lot of time and a lot of cost. So you have the possibility of having one procedure resolving all the disputes. And I will also share a couple of case examples where this was the case, where there were cross-border disputes in multiple jurisdictions, and through the mediation, the parties managed to resolve their disputes in all the countries involved. Confidentiality, as Jevon mentioned, that is actually an aspect which we see in practice being really important for parties. Of course, whenever there is confidential information through secret or sake, confidentiality is really of the essence. But also sometimes just for reputational reasons, parties have an interest in keeping the proceedings confidential, and particularly under the WIPO rules, so we have a very strict confidentiality code, which ensures that all the proceedings and whatever is shared during the proceedings remains confidential. And then this goes for mediation, because as you were saying, arbitration is more adversarial, so more similar to litigation in that way. But mediation is a very unique procedure where actually the mediator does not impose a decision, but helps parties finding a solution. So it really helps bridging the gap between the two parties. So it has a more constructive nature, and this in practice, we see in our cases, really helps the parties whenever there was already a collaboration between the parties to resolve the dispute, and then after the dispute has been resolved, actually continue with the collaboration. So mediation can really help parties preserve their business relationship. So it goes even beyond the dispute resolution. And I think also for a business, it's something which is very relevant, and also in IP and technology related collaborations, where you have collaborations such as research and development agreements, which take a long time, where collaboration is important, is a great advantage to keep in mind. So these are some of the reasons why mediation, arbitration could actually be very efficient or effective ways of dealing with the disputes. So what do? A few words on the center. We administer these disputes. So we provide mediation, arbitration services. Also, WIPO, being an agency of the United Nations, is completely neutral. So the WIPO Center is a complete neutral forum, meaning that it has really no connection, no link with any jurisdiction or law or institutional country at all. And this is something which can be an advantage if you're involved in an international collaboration or dispute, because then the WIPO Center is really a neutral forum. So this means that none of the two parties has any home court advantage. So none of them is more familiar with a certain jurisdiction or language. So that's something to keep in mind if you're ever involved in an international dispute. And of course, because we're part of WIPO, we also specialize. So while our procedures are being used for any commercial dispute, we also have a specialization in intellectual property and technology. So for example, we have a database of experts that I was mentioning before. It's more than 2,000 experts based in different parts of the world, speaking different languages. So we have that expertise that we can offer in our cases. And then if you look at our fees, they're really, we call them not-for-profit, in the sense that we try to keep them as low as possible to also facilitate access to mediation and arbitration, especially for SMEs, where we also have further reductions. And then in the specific case, because really every case is different, and we see cases where the amount of dispute is billions, but also cases where the amount of dispute is much less. So we always try to tailor and adjust the fees depending on the specific case. So how can we help? And I think I saw in the Q&A also questions related to drafting clauses. So perhaps I'll just say a few words about that. So actually, even before there is a dispute, we can help parties giving procedural advice. So for example, we can help them drafting clauses, because really the starting point for mediation and arbitration is the agreement of the parties to choose mediation or arbitration. And if you have a collaboration, the easiest way of doing it is to include that in a contract. So we can help you draft clauses. We have model clauses on our website that you can use, so that you can take, but you can also get in touch directly with us, and we can help you review the clause, tailor it to the specific collaboration. So we really encourage you to do that. Of course, it's something that we do completely free of charge. And then whenever a case, a mediation case, an arbitration case is filed, WIPO will administer the case. So this means that we make sure that the case is on track. So we facilitate case communications, we fix the fees, we help parties negotiate the fees. We also provide online facilities. And this is something that we have seen, of course, being used in almost every case in the last couple of years. And so far, I have to say, he has worked very, very well. He has seen that even the settlement rate, which was already very high, 70% in the last year, where online means were used, actually jumped to almost 80%. We found that the parties feel, and the mediators, arbitrators feel very comfortable with it, and it also helps parties saving time and costs. Also, in terms of time, it's much easier to schedule a meeting online than to actually find an actual day where people have to travel. So far, we had a very good experience, and that's something that we can also provide. We have our platform, so we will also do some trainings with the parties so that everyone is familiar with the platform. And then, and I think this is probably one of the most crucial points of our work when we administer cases, we help the parties find a mediator or an arbitrator. And of course, we have this list of WIPO experts where parties can choose, but of course, they can also go beyond that list. And I really want to stress this point because the choice of the mediator or the arbitrator is really crucial always, but especially even more in intellectual property or technology disputes, because they can be very specific. So sometimes it may be helpful to actually have someone with a specific expertise in the context of the collaboration or the specific dispute. And when we do that, when we select and appoint a mediator and arbitrator, we try to do that actually involving the parties as much as possible in the choice. So what we do in practice, we really contact the parties and we ask them what are their requirements and the characteristics that a mediator and arbitrator should have. And that can be in terms of expertise, but also geographical location, languages, even culture. So that's a very important part of the mediation arbitration process. In case you be interested in knowing a bit more on the online conduct and how we do that in practice, we've also come up with a sort of checklist that summarizes a little bit our experience. And we have rules, mediation rules, arbitration rules, which of course being really thought for intellectual property disputes have some specific provisions for intellectual property disputes, technical evidence, confidentiality, but at the same time, really these rules are quite flexible. They are suitable to all commercial disputes, and they're flexible in the sense that they help give the procedure a structure, but then at the same time, parties retain a lot of autonomy, and this is really one of the advantages of mediation arbitration. In most parts, parties can actually modify the rules in agreement with the mediator and the arbitrator. So, for example, in terms of timelines. And we also have recently updated our rules, actually just in July. And for example, we have now some express provision which allow filings online, also meetings online. So we will really try to reflect a bit of our latest experience in the new rules. And I wanted to show you also this document. This is what we call a unilateral request for WIPO mediation. And we see that very often used when parties do not have a collaboration, but there is, for example, an infringement situation. So one party sees his trademark rights or design rights or patent rights being infringed by someone that they don't know. So we give the parties the possibility of requesting mediation unilaterally. And this has been also very frequently used by SMEs. It's also free of charge to file a unilateral request. And the way it works is that it's a one-page document that can be filed with us with some information on dispute and the other party. And once we receive this request, we actually get in touch with the other party and we try to convince the other party to consider mediation. And this is something that we have seen quite helpful, because especially in infringing situations or where the requesting party does not know the other party, sometimes if the request comes from the WIPO center, then the other party is more open to consider the mediation option. And of course, being free of charge, there is literally no risk or no cost associated to it. So that's something that we always encourage trying, and that's a way to start the mediation process. This is an overview of our experience to also give you an idea of what kind of cases we see. Patent cases are still the highest one, but we see that, for example, ICT and software cases are also picking up. We see many of them, and we also see just some regular commercial cases where there is no IP element in dispute. So you also see also the geographical location, so it's really everywhere. And then I wanted to just spend a couple of words on the settlement rate. So this means that in 70% of our WIPO mediation cases, the parties reach a settlement. So they manage to resolve the dispute amicably. And even in arbitration, normally parties do not look for a settlement, but rather for a favorable decision from the arbitrators. But sometimes in our cases, in more than 30% of the case, the parties find a settlement. Very often that's because they had a WIPO mediation phase before, and then during the arbitration they realized that there could have been room for settlement, and they decide to suspend the arbitration and they settle. And also in 2020 we really observed a higher settlement rate, close to 80%, also an increase in cases. So apparently there is more awareness of these options, and we think that also the fact of having this online option as a way to also saving more time and more cost is one of the reasons for that. And now, before I close, I just wanted to go through a couple of examples. These are real cases that were administered by the WIPO Center to give you an idea of how the procedure works in practice. This first one was a case that I administered when I was in Singapore. It's in the area of trademarks, and here we had a businessman from Thailand and a company from the United States. So this is the cross-border dispute I was mentioning before. And here it started off with a trademark opposition and invalidation between the Thai businessman and US company in Singapore before the IP office there. And in Singapore, whenever there is a trademark proceeding, the parties also have the option to start a mediation and to see if they can resolve dispute with the mediation. So in that case, the parties selected WIPO mediation, and we appointed a mediator with a specific experience in trademarks based in Singapore. And then it was very interesting because during the mediation process, before the parties met and all, but right at the beginning, the parties actually realized, wait, we have the same or a very similar dispute actually in a few other countries. Vietnam is one of them, but also Indonesia, the Philippines, Thailand. So they actually decided to take all these disputes in the mediation. So they expanded the scope of the mediation, and all these disputes were heard during the mediation. So this was also a way to resolve cross-border disputes in multiple jurisdictions using one procedure. Here, this was before the pandemic, the parties had a mediation session, a physical one in Singapore, which lasted 1 day, and the parties were actually able to settle all disputes. The duration was 4 months, and they resolved these disputes in all those countries. So in this sense, it was also a very efficient way to resolve the dispute in 6 countries only during 1 day. And in this particular case, WIPO, the Office of Singapore, also offered under some conditions some funding to the parties. So the cost was very contained for the parties. And this is another mediation where we had two startups, one from Asia and one from the US. This was different. This was in the area of software. So it was more of a commercial agreement. It was a license agreement. It was about mobile applications. And the dispute was really more of a commercial one, royalty payments, the use of the software, whether it was authorized or not. So here the parties had a contract, so it was a different situation. And the contract provided for mediation followed by WIPO arbitration. And the parties here, they requested specifically a mediator with also experience in technology and software cases, because for them it was also important to have a mediator that understood the context and the background of the collaboration. So we found a mediator, we appointed the mediator, and here it was also very interesting because the place of mediation was supposed to be, if I'm not wrong, it was supposed to be Paris in Europe, but that was really not convenient for the parties, which were based somewhere else. And they also had some very sensitive cost considerations. So they wanted the mediation to be done very quickly, and also it was not convenient for them to travel. So they actually agreed with the mediator to have the whole proceedings by telephone, not even by video conference or online, just by telephone. The mediator agreed, and the way it was structured is that, of course, there were both parties and other calls with one party only. And also in this case, the parties managed to settle within 3 months. And here, the parties actually were able to continue the collaboration. So this is where I was mentioning that mediation, because it's not as confrontational, can also help the parties preserve the business relationship that they have, so actually going beyond the dispute. And also I think from a business point of view, that's really something that mediation can offer that other procedures cannot offer, so really something to really keep in mind. So with this, I will conclude the presentation. I don't know if there is any question we should address now, or later on.
Thank you very much, Chiara. I suggest that we move on to the next presentation and go for the questions at the end, if that's okay. I just want to tell our audience that we are a little bit running out of time. However, I see you are still here with us, so thank you very much. That's a good news, and please stay until the end, because we are going to have a very interesting Q&A session. I think this topic has a lot to say, so hope you are fine to have a little bit longer webinar. So now, without any further ado, I would like to pass the floor to Huong Tran to discuss more on the commercial mediation in Vietnam.
Yeah, thank you, Nora. Good afternoon, everyone. Thank you to two speakers for your very informative presentations. First of all, I'd talk about a little bit about myself. My name is Huong Tran. I have 18 experience practicing in IP law. And before I worked for NLIP, and I examining over 30,000 trademark applications for NLIP. And now I'm running IP agent as a ratio IP agent and investment consulting within the scope of my experience. Okay. Oh, I need to change my slide. Oh, I don't know how to. Nora, can you help me? Yes,
Yes.
I try to smooth my slides, but nothing happened.
Okay. So probably we share your slide and give the control to you. Let's try that.
Yeah.
Chang, if you can help.
Okay. Yep. Perfect. All right.
Can you change?
Yeah. Can you see my my screen?
I see the screen, but only the first slide. Can you move to the next slide?
Okay, it's all right.
So
on my screen, I can see I can change this, but I don't know what display there.
Okay, don't worry. I suggest that we share the slide, so you just tell us when we move to the next one. Okay.
All right.
Okay.
Oh, you have me change my slide, right?
Yes. So let's move to the next. I think we can go ahead.
Yeah. So now I want to show my agenda. All right. So within the scope of my presentation, I would like to present the topics: introduction of commercial mediation in Vietnam and current practice. My agenda is have three parts. Part one, introduction to commercial mediation in Vietnam and the legal framework. And part two, I will skip it because I know already the two speakers talk about that. It's about advantages and challenges about commercial mediation. And I forgot about part three, overview about Mediation Center, VICMC. Let's move slide, please. Firstly, let's discuss about introduction to mediation in Vietnam and legal basis. Traditionally, dispute resolution within commercial activity usually follow four pathways where the party chose. One, negotiation between the party. Two, mediation between party chosen by an agency, organization, or individuals as agreed by the party to act as a mediator. Three, settlement and commercial arbitration. And four, settlement in the court system. Each method has its own advantages and challenges, and this diagram shows the different degree of control of the parties and the time to resources devoted to dispute resolution. For example, in negotiation and mediation, the degree of control of the party is the most significant, and the expense are minimal. Whereas the court pathway shows the lower degree of control of the party, but it's noted that the time and cost increase significantly. Now, please take 30 seconds to answer a small question. Let's choose the correct response. What is the average time to resolve a contract dispute in the court? A, 90 days, to B, 120 days, C, 250 days, and 4, 40 days. That take 30 minutes. Can we look?
Okay.
Yeah.
A few seconds, and then we will share the result, and Huong can comment on it.
No, right now you are sharing it.
Yes, we will share the result now.
Okay, so now don't worry.
And you should see it. Okay, so 49%.
Yeah.
Jesse, that is 400 days. So
yeah, it's 400 days. Wow, it's very interesting. Well, I can't believe most of you answer is correct. That's 400 days. Please examine this table. The business environment reports from 2014 and 2019 shows some results. The average time to resolve a contract dispute in the court is 400 days, which means that many cases take longer than 400 days in practice, possibly up to 3 years for IP related cases or domain names disputes. And what I can see, a notable figure is that the cost fee is quite low. accounting for only 5% of the total value of the dispute. However, legal costs and contract penalty costs are up to 50%. Thus, on average, after waiting for more than 400 days, the fee to be paid to be the court may be total 55% of the total dispute value. So in Vietnam, we don't want to go to the court actually, but it seems we still don't have a lot of choice because mediation is still very quite new, and I will show you later. And about on the court, the time in the court is thrown out significantly. The information is unsecure, and there are concerns about unfairness. Even when the case is settled, enforcement is difficult and lengthy, and the recovery rate after litigation is often minimal. Today in Vietnam, next slide please. Today in Vietnam, according to the law, mediation methods in dispute settlement can be divided into two types. The first is compulsory mediation according to the court procedures, and the second is mediation as agreed by the party as commercial mediation. In the compulsory mediation methods according to the court procedure, it is an action that is actively carried out by a subject conducting the proceeding according to the legal order and procedure within civil procedure. In my presentation, I only focused on the methods of mediation activity conducted by the party is the commercial mediation. Next slide, please. So about legal framework requires for mediation include we have commercial law 2005, civil law, law on investment, IP law, and we have Civil Procedural Code 2015 and Decree 22 2017. The Civil Procedural Code 2015 is stipulated on Chapter 3 on recognizing result of successful mediation out of the court. In addition, it also clears stipulation on condition, procedures, and requirements for application to recognize the result of successful mediation out of the court from Article 416, 419. Well, the time of commercial mediation was recorded under commercial law 2005, but it is very long way from being recorded in the commercial law until 12 years later, November 2007, Decree 22 was enacted, realizing the provision of the 2005 commercial law on commercial mediation. The enaction of Decree 22 is a new step to promote the development of commercial mediation. In addition, in strengthening and legal basis for commercial mediation, Decree 22 has defined the scope of commercial mediation, which is dispute between parties in which at least one party is involved in commercial activity. Another dispute between the party must be resolved by commercial mediation and according by the law. So about IP disputes, I think most IP disputes can be commercial dispute because at least one party is have commercial activity. For example, they act as a company or businessman or something like that. And in addition, Decree 22 also stipulates the order and procedure for commercial mediation, standards of mediation and mediation center, and regulation binding the operation of foreign commercial mediation center in Vietnam. So after enact of Decree 22, there was about, I think, my update number is maybe 10 mediation centers who were established in Vietnam. However, I believe that just maybe only 2 or few the mediation center actually have active and handle cases in the center. That's including Vietnam International Commercial Mediation Center, VICMC. So VICMC is the first commercial mediation center licensed by the Ministry of Justice on 2018. VICMC quickly went to operation with the aims of providing the business community with an alternative dispute resolution option. In addition to conducting commercial mediation activities, VICMC also focuses on training activity for mediation. And every year we have maybe two or four courses about training for new mediators. VICMC is already located in Hanoi and Ho Chi Minh City, and we have more than 60 highly trained and certified mediation from world's leading mediation organization. We have successfully mediated numerous disputes, and we already have some cases after three years established. VICMC also operates strongly in different professional groups such as dispute broad group, energy and infrastructure groups, IP group, M&A group, and shareholder and dispute resolution group. With professional activity, cooperation, and training throughout Vietnam, VICMC's own way, and a unit for a party to trust and children to implement when a commercial dispute occurs. Especially for dispute over IP, VICMC have a very efficient and strong group. It's an IP group. We focus on IPs and technology disputes. And about IP, particularly of this, my colleague, Mr. Doan, will present shortly on specific issues related to IP dispute. To sum up, we are pleased to welcome experts from all field and international mediation to join VICMC. And for more information, please contact me, Mr. Sun, or even VICMC secretary to source on the last slides. Mainly because of time limitation, I am sorry, I cannot mention more about information about VICMC dispute handling process, template terms, and mediation rule and fee, but everything you can see if you're interested. Just click on the links on the last slide and already have the link. And even we can make some video to show the mediation process. And thank you for your listening, and see you in the Q&A section. Thank you, Nora.
Yeah, thank you, Huong. And actually, if there is any information that you did not have time to mention, we can include those links also in the follow-up email that is sent out to all our participants and registrants for this webinar. So don't worry.
Yes.
We'll share all the information. So now let's move to the final presentation with Son Doan, and after that we have still some time for the Q&A. So Son, the floor is yours. I cannot hear you.
I'm still
muted.
Thanks, Nora.
Okay, good.
You see my slide?
Yes,
Thank you.
I can see the slide, full screen, all good.
Thanks, everyone. Because of the time constraint, I will go straight to the presentation. I will speak very briefly about IP dispute resolution in Vietnam, and then with some more information about IP dispute resolution through commercial mediation and a case study. So I will actually bypass the first question to save time, the first poll, if you all agree.
Yeah.
Yeah, about Vietnam IP dispute.
No, we move on the first.
Okay.
Okay, we just close the poll and you go with the next slide.
Thank you. So in the chart on the slide, you see the available option for I think the poll option still on the screen. So if Nora can have to. Okay, thanks. So the available procedure for handling IP case, IP infringement, IP dispute are shown on the table on the slide. See, in addition to procedure at the IP office, like opposition and cancellation. For enforcement, you see we have the C in desist letter procedure, negotiation between the parties. Actually, we have administrative enforcement procedure covering many IP rights infringement case, and criminal, civil litigation, arbitration, and mediation. As you can see from the statistic I would show in the subsequent slides, administrative enforcement still the most common route for enforcement against and resolving IP dispute. One of the reasons is because most of the case in Vietnam are still very straightforward infringement, piracy, counterfeit, but we also see an increasing number of more and more complicated cases, particularly in patent, in validity of certificate, and as well as copyright. The poll I would ask Nora to have. The question is, which procedure is most suitable to resolve your IP dispute? C in this letter, administrative enforcement, criminal enforcement, litigation, arbitration, and mediation.
Yeah, so we launched the poll, and participants can select multiple choices. Okay, so you can click on more than one options. Let's leave 20 seconds only, because we have less time. So we are expecting a fast answer from everyone, and then someone can comment on that. Okay, let's see what our participants think. Okay, so majority is on mediation.
Thanks, Nora, and everyone. We see the majority's answer is mediation, which is quite good. And I see synergies letter is also very one of the very most effective way. And civil litigation, administrative enforcement, arbitration, and criminal enforcement is less, which is kind of a little bit surprised to me within the context in Vietnam, which I will explain later in my subsequent slide. But that is very positive information for me, actually, and our mediators. So we move to the next slide. So within the IP office, we see some statistics in the last 3 years. The cancellation, invalidation case, the opposition case, the appeal, and the court case. You see that the case being brought to the court concerning case in Vietnam is still very limited as compared to cancellation on opposition and appeal procedure at the IP Vietnam. But we started to have case from and at the IP office being brought to the court, which is showing that the case, more and more complicated case, there will be decision of the IP office being challenged by the parties, and it even went to the court. And so it shows the trend that more and more complicated case that would involve the court, and the time frame handling this dispute case at the court often prolonged to from 1 to 5 years, even longer. And because of the complicated needs of the case, because of the heavy workload of the IP office and the lack of the staff members, and as one of the things that we also learned that the IP office of Vietnam is also looking at looking into the experience from other countries and having utilizing mediation into the procedure for handling case, which they would like to facilitate the discussion, the negotiation, the mediation between the parties to reduce the workload and to have more case handled effectively. So we are hopeful that more procedure will be introduced in the future. In terms of enforcement, you see that the majority of the case in the past year would be still administrative enforcement. As I said, the main reason is because of the fact that the majority of the case actually straightforward infringement, the direct copying, counterfeit trademark goods, and pirated goods, and things like that. But we also see there also the more complicated case that go to the court, and there'll be more and more. And the other reason is that administrative enforcement is more effective in terms of handling infringement, stopping the infringement in terms of time, cost, and for civil litigation, still limited capability of the court in handling IP case, as well as the uncertainty of the outcome, which is also a concern to IP right holder. As I said, because of the developments, more and more IP case involving IP dispute in complicated field like copyright, patent, certificate validities, as well as transfer, technology transfer contract, licensing contract, and R&D agreements, employee patents, and things like that. There will be more and more dispute rising from these, and that would be opportunities for mediation in Vietnam for the parties to look at. One of the strategy set out clearly in the National IP Strategy to 2030, promulgated by the Prime Minister in 2019, is to increase resolution of IP dispute by arbitration, promoting mediation practice for resolution of IP right. So we hope that more and more mediation procedure would be provided in laws and to be promoted more to facilitate IP dispute resolution in Vietnam in the future. Here we see that I set out some, not all the IP dispute are suitable from commercial mediation, like as I said, intentional or repeated infringement, for counterfeit good or pirated good, then or for case where IP right holder would like to seek clear precedents and to deter and educate or take action against future infringement, then this case may not be suitable for commercial mediation. But many other cases that would be within the so-called case that maybe for that commercial mediation may be suitable. As I said, unclear, straightforward infringement, not straightforward infringement, case relating to ownership right or agreements, licensing, franchising agreement, or case involving multiple IP rights of the parties, where the rights can complement each other, and a party would like to look into some beneficial solution for both and to build up the relationship for future developments of the businesses. And this case would be very suitable with commercial mediation. So some tips for resolving IP dispute by commercial mediation in Vietnam. The first one is that some agreement may not be enforceable or not accepted by authority, or even not legal. For example, agreement on license of expired patent, or agreement on acquisition of very, very highly similar match that may still cause confusion to the consumer in the market. Agreement for the sale of counterfeit goods, then that is not acceptable. On that, second tip would be the settlement agreement should need to be supported by detailed implementation plan. Of course, if the agreement will be recognized by the court decision at the request of one of the parties. But without the detailed implementation plan, then there will be the area for a dispute be arisen and in implementing. For example, some following action by each party, like filing the withdrawal of cancellation request, filing the withdrawal of the opposition in the trademark office, and things like that would be set out in detail in the agreement to avoid dispute, a future dispute on the agreed solution. The other thing is to monitor the statutory time limit and deadline for related procedure to secure the position during the mediation process, like the deadline for filing appeal, opposition, cancellation, deadline for filing civil lawsuit, monitor the term of protection of the disputed IP rights. For example, some disputed IP right may expire during the mediation period, then that would change the position of the parties in the dispute. The selection of the right mediator with appropriate experience is also very important to have to handle, to facilitate and support the parties in handling the dispute more effectively, and to come up with opportunity for the solution that is most beneficial to the parties. So actually, I will bypass this first case study and go to the second, the case study to end my presentation. The case involved a designing company that was engaged by a bidding company in preparing the design work for bidding for a power plant project. Then it was understood from the engaging agreement of the design company and the bidding company that the bidding company shall appoint the designing company as a subcontractor for performing the work under the engagement agreement after the acceptance of the bids. Then the bidding company subsequently appointed another subcontractor and using the material from the design work prepared by the designing company for implementing the project. And the provision in the engagement agreement stated that the designing company retained the ownership right on the intellectual property rights in on the deliverable in the design work, and subject to the payment of the designing fee for the design work, then the designing company will grant to the bidding company a non-exclusive, irrevocable, royalty-free, transferable license to use own IP right in the own deliverable for the construction project. And the engagement agreement is governed by the law of UK, and only disputes can be resolved by arbitration at the HCF. And then the parties went on to communicate with each other, retaining their position. Designing company request for the completely seizure of use of the copyrighted material in the design work, and the payment of the remaining design fee and the subsequent fee for the delayed payment, and compensation for the breach of the contract and copyright infringement. Meanwhile, the bidding company position is that they are entitled to use the deliverable works, and that is within the consignment. And for that, the designing company has been paid, and they would be prepared to pay the remaining fee. But after the submission of the remaining deliverable work in the contract of the design work that the designing company hold off. So the parties went on dispute and arguing for quite a long time, and inviting experts in discussion, and then after consultation with the mediator, they agree to submit the case to the mediation center. So the expectation that we understood from the designing company is that for the project, the construction project, they would not pursue to be the subcontractor, and they would be prepared to allow the bidding company to continue using the design work but they would like proper remuneration for the work carried out under the design work, the preparation step, because their position is that the designing fee for the design work in the engagement agreement is not standalone fee. That is the fee with the consideration that they would be appointed as subcontractor to carry out more substantial work during the subsequent step. And they also would like to seek further cooperation with the bidding company in the future project. There are many opportunities for them. Meanwhile, the bidding companies also would like to make sure that they are free from legal risks for using the design work for the ongoing project, and they would still very highly appreciate the designing works, and they would like to maintain the good relationship with the designing company for future collaboration in future projects. So that is the position of the two parties, and they were preparing the submission to the mediation center, but at some step before that, they have entered into an agreement without going to the mediation. So that is kind of internal agreement with them, and we guess that they have ended the dispute and for the longer cooperation with each other, and they all get what they expected. The case indicate three things. One is that dispute like this will happen more and more in Vietnam because there are more and more transactions in more kind of agreements with different rights and mechanisms of the parties, and why the party has not paid very due attention to specific provision in the agreements that would cause the dispute. That would be meaning that the second is there will be more and more kind of dispute like this, and that would be the opportunities for mediation to be utilized, and would offer the very effective way to resolve the dispute between the parties. And the final point is that dispute, especially IP dispute, the parties always can look into mediation as one way of resolution, and that would be very beneficial. Sometimes it may come up with a very innovative solution for the parties. The interest benefit of the party is not always conflicting and not complementing each other. So by that, I would end my presentation and leave the forum to Nora for Q&A. Thank you.
Yes, thank you very much, Ton, for the insightful presentation. That we have an overview about Singapore, Southeast Asia, and Vietnam on this situation now. And yes, let's jump immediately on the Q&A. We just wanted to share with you one slide. I think about we have a guide on ADR, which was actually drafted in collaboration with Jevon, and also Chiara on behalf of WIPO contributed one chapter. So we are very proud to let you know that now finally it's online. So we put the link where you can download the guide, and related to today's webinar, you can find more details. So please feel free to check it out. And now I would like to give the floor to Benoit to take care of the Q&A session. And yes.
Okay, thank you very much, Nora. Thank you very much to all the speakers. We are like running a bit of time, but we'll try to go fast. So I have several questions for each of you. And the first one will be to Chiara, because we received one about WIPO view towards Singapore Convention in mediation, how mediation work group could assist and to be included in the form of close agreements to avoid waste of court time and resources by making an alternative dispute resolution in advance?
Thank you, Benoit. For the Singapore Mediation Convention, of course, it's a great development because basically it's trying to do what the New York Convention did for arbitral awards. So it's boosting in a way the enforcement of mediation settlement agreements. So for the countries which have ratified the Singapore Convention, then it will be possible to actually enforce the mediation settlement agreement. And not just have a force of contract. So it's something that, of course, it's very welcome because it gives more strength to the mediation process. Now, one thing I wanted to share is that we actually see that, at least in our cases, usually there is no need to it. Because usually parties actually comply voluntarily because at the end of the day, the mediation settlement agreement is the party's decision. So we don't see it happening in our cases that one of the two parties does not comply and there is need to enforce it, but at the same time, better safe than sorry. So it's another tool to really promote and give more strength to mediation. So of course that's very much welcome. We also updated our rules, including references to the Singapore Mediation Convention. And that on the second question, I think that goes really to the drafting. So how parties can basically think about dispute resolution in advance. So the easiest way, and really this is something we always encourage parties, businesses, individuals to do whenever they enter into a collaboration, is to include a dispute resolution contract clause in their contract. So this way, when a dispute arises, where they are at the point where it's really hard to agree on anything, they already have the mediation, the arbitration clause in the contract. So that's something that we really suggest to do. And it's very easy. We have, for example, model clauses in 9 languages on our website where you can also combine mediation, arbitration, court litigation, depending on specific collaboration. So just use, copy, paste that in your contract, and then you can also come to us if you want us to review it, if your collaboration is a bit more particular and you want to have a more tailored approach. But the short answer is to include a dispute resolution clause in the contract itself.
Okay, thank you very much, Chiara. I saw also that we had a question which was partially already answered by Son. It was on the cost and efforts with going with a mediator as opposed to a law firm handling a dispute. What are the examples you could share where the negotiation is no longer an option? Do you want to share a couple of examples again?
Yeah, let me go back to my, so in my screen, in my slide, I mentioned the types of different IP dispute and what is suitable for mediation. Commercial mediation would be suitable for handling this dispute. So I think for case like trademark counterfeiting or intentional infringement, or case where you would like to have a very effective precedents set out and to public side to set out as a precedent, send a strong message to the infringer to deter future infringement, and educate the public, educate the possible future infringers and things like that. Then that for this case, you may want to go to the other enforcement route, like in administrative procedure or civil or even criminal case, instead of using mediation center, because it would unlikely to be any opportunity for the other party to agree to mediate or to comply with what you expect. But for many other kind of dispute, like authorship rights or arise on the IP right that arise from the employment agreements or from IND or from licensing agreement between the parties, or concerning the authorship right and things like that, or unclear infringement, like the borderline case, where we are not sure whether that will be infringement or not, and things that may it will be very costly and takes long time to go to the end. Then mediation is quite suitable for handling, and of course the counselor would be need to be consulted in own case. And I would recommend even when you go to mediation as well, the counselor the counsel would give you advice on your position on the pros and cons, and even in the mediation as well, they would be a resource of laws and position, and if they understand your businesses, your position, and then that would be a very helpful support in even mediation process as well. Because if you go to enforcement, administrative right or criminal case and civil litigation, then they absolutely you need the support from local counsel.
Okay, thank you very much. And I guess that if anyone has a specific question, it's also always good to contact either WIPO MC or IP expert, IP lawyers. So we also recently, it's like always, we say that mediation is more interest-based procedure. Arbitration is centered into rights. We saw the advantages, but we didn't touch much about the challenges. Maybe Ms. Huong, you could share a bit with us about the main challenges?
Excuse me?
Yes, could you share with us a bit about challenges with alternative dispute resolution?
Oh, sure. Thank you, Benoit. So about challenges about mediation in Vietnam, so we have still have some challenges at the same with Singapore or even international, even on commercial fields or IP field. So it's some is quite the same. But one of the most challenges for Vietnam, because maybe I just think because maybe mediation is still quite very new in Vietnam. We just have only a few years to enact decree 22 for mediation, and normally people still don't. Normally, even lawyers, they don't know what is mediation is, or maybe they has mixed understand, or something is mixed between the procedure with the courts and mediation. Compulsory on the court is doesn't work. I have to say, maybe some it have, but maybe for about marriage or divorce, something like that, maybe it have. But for companies, maybe not. And most of all, we don't think it does work. And even commercial mediation is it's the same way. Just they still use the power to talk. Ex party have to do this, so to do that. Is not similar with the commercial mediation, and that's why for first step, and we try VICMC, we try to educate the market. We try to educate the new lawyer and cooperate with many provinces in Vietnam and university. And I think the second reason. As the second reason is the mediation agreements, successful mediation agreement. It needs to maybe we still have procedure to the court accept that, and most question the audience is always ask us is what happened is possible if the court may not recognize successful mediation agreement. This is very, normally question and concerns about that. But we believe that in practice, we have in contrast on successful mediation agreement as a voluntarily implemented by the party very quickly without any recognition by the court. That is a real life. Because it's very normal, because if it does deal with a win-win and justice, and there is a pride, because party, and they happy to enforce this. But for the party, but for the company or even lawyers, they never knows about it, and they still question. And I believe in the future that challenges will be not longer. Thank you for your. Yeah.
Thank you very much, Huong. And yes, it was part of also today's webinar to raise awareness about ADR, and I hope everyone learned many things. I do have one question, a bit technical for Jevon, as he's in a law firm in Singapore. What are the factors one should consider when deciding which ADR institutes to select?
Thank you, Benoit. I think there are a few factors to consider, and they're quite important. One, for example, would be the rules of the particular institution. Some rules are quite unique and specific to certain institutions. For example, some institutions have, and they allow restrictions on the nationality of the arbitrator whom you're going to appoint. SIAC, for example, doesn't have such restrictions, so that can be a factor when you're looking for neutrality or insofar as the nationality of the arbitrator is concerned. You should also consider the institutions that are flexible and provide mechanisms. For example, you have something called the ARB-MED-ARB, which means arbitration, mediation, and then arbitration again. So where you start off an arbitration, you may break and try to have a mediation in between to resolve the matter. And if you can't, you can go back to an arbitration and resume your arbitration. So those that have such flexible schemes might be preferable. Those that provide for expedited arbitration. Another area is, of course, the subject matter in question, IP being usually of a technical nature possibly, or having subject matter expertise. That's very important when considering a suitable institution to select. I think the last factor I would consider would be the neutrality and the venue of where your proceedings are actually going to be taking place. Because it's quite easy to say that two parties come from different countries and they just choose a neutral territory where this will happen. It's not so practical sometimes when it actually plays out. So that's also a factor to consider. Having it in a specific venue can lead to added costs also. So these are the different factors to consider, I think, when you are drafting your ADR clause and selecting a suitable institution.
Yeah, very clear. Thank you very much, Jevon. And well, there are still several questions, but we are running out of time. So I will just quickly wrap up. Thank you very much to everyone for assisting to this webinar. The main key message I would like to share on behalf of the Helpdesk is that there are many advantages using ADR. Everything was shared today, and I hope that we went into sufficient details, but mostly it's time-saving and cost-effective for companies. There is privacy and confidentiality, so it's good for the reputation of companies. There are neutral and professional experts that you can have and discuss with, and there is also like a real discussion between parties that could also help to maintain good relations with partners. After listening to this webinar, I think that now we have a lot of more information, and if you like the topic, you may learn more about it by checking the guide we just shared the